Welcome once again to Lehto's Law. Here's Steve Lehto.
Bright enough for you? Went to the P.O. box the other day, got some mail, and along with some very, very nice gifts that people passed along, there was a newspaper article folded up and stuck in an envelope sent to me with no return address, but it was postmarked Miami. And a handwritten note on a Wall Street Journal article, and I opened it up and it says, "Growth hits 6-year low in Germany." And I thought, no, I'm just kidding. Other side. Steve, better than asset forfeiture, huh? And this is an op-ed piece by Robert McNamara, who is an attorney at the Institute for Justice, which is a nonprofit public interest law firm in Arlington, Virginia. But a viewer sent this along, and thank you very much for passing this along. I do open and read all my mail, whether it's email or the old style analog mail, I like to call it. And what this article is about, I've talked about before. In America, if you have a home, your home is your castle. The government can take your home from you, and they can compensate you for it. And there's a case called Kelo, which I've talked about before. In my opinion, is one of the worst cases ever by the U.S. Supreme Court. And they actually said that the local governments, the state governments, can actually say, you know something, we don't think your property is being put to the best use. We're going to actually condemn it, kick you off of it, give you fair market value for it, and give it to somebody else who will put it to a better use. Now, that kind of action used to be allowable and fairly common with respect to things of a public nature. They want to run a highway through an area, and some guy's got a piece of property, and the highway goes like this, and it's going to continue like this, and this guy goes, I'm not selling my property. Well, they'll say for the public good to run the highway through there, we're going to do that. So they'd often be doing it for public things like that. But Kelo said specifically that, oh, and by the way, they can do it for a private company as well. And so they were going to just take this property and give it to a company, and the company's going to build a factory or something. Never happened. And the woman lost her house. They made a movie about it. But I've also talked about how occasionally the government can destroy your house, and if they do it for a good reason and under the right exception, they can get away with it. And there was a case I covered before about the police were chasing a shoplifter who'd stolen, I believe, a belt from a store. Now, there was a gun involved in the story. I'm not trying to leave that out. But the man barricaded himself inside someone else's house. And the police proceeded to, in essence, destroy the house in an attempt to get the man out. They eventually got the guy out. And the house was destroyed. And the police said, well, that's too bad. We had to destroy our house, but that's what we do. And we're doing our jobs, and that's too bad. And that went up in the court systems out west. And the higher court said, you know something, unfortunately, the way our laws are currently written and under the current state of the law, qualified immunity is going to protect the government so that you cannot sue them for that. And most people, when they hear these stories, go, wait, what? They destroyed your house and you get no compensation? And I've had a lot of people mistakenly say, Steve, that's okay. Homeowners insurance will cover it. No, they won't. Why would they cover that? Homeowners insurance has exclusions in there. There's certain things they cover, certain things they don't cover. And one of them is this. Another one might be an act of war. But Tear Gas Grenades and Qualified Immunity by Robert McNamara tells the story of Shanna's West, who was in a hurry because she had to register her children for school when local police officers approached her outside of her home in Caldwell, Idaho. They were looking for her ex-boyfriend on firearms charges. They asked Ms. West, is your ex-boyfriend in your house? And she said that she didn't think so, but if they wanted to, they can go inside and look for him. And she handed them the keys and said, go inside and look. But she was in a hurry to go register her kids for school. The officers did not go inside to check. Instead, they called in a SWAT team, launched an hours-long siege, repeatedly using shotguns to blast tear gas grenades into every living space in the home, and wrecked the house. Broken windows, holes in the wall, holes in the ceilings, and there was a yellow sticky film over everything in the house. And by the way, the boyfriend was not inside the house. The police spent the day bombarding a house that was empty except for Ms. West's dog. And the dog's name is Blue. And I'll include that because we know it as a fact. The home became uninhabitable, and Ms. West and her children spent the next 2 months homeless. She sued the officers responsible, arguing that the warrantless destruction of her home violated her Fourth Amendment rights against unreasonable searches and seizures. The officer's defense was they didn't need a warrant because she gave them permission. Now, she gave them consent to go look for the ex-boyfriend. She didn't say destroy the house in the process. But they argued that once a person gives consent to enter a home, they cannot limit the tactical plan and safety precautions used by police officers to conduct a consent search. So no judge has held that what the officers did to Ms. West was legal, but the Ninth Circuit Court of Appeals rejected her claim, saying that she lost because of qualified governmental immunity. A government official can be held liable for civil rights violations, but only if the constitutional rule he broke was clearly established. Not clearly understood or clearly something everyone knows, but clearly established by case law. And as of right now, the case law all says they come in and they destroy your house. Too bad. The Supreme Court established this doctrine in Harlow versus Fitzgerald in 1982, where a civilian Air Force employee sued the Nixon administration, alleging they had conspired to fire him. By an 8-1 vote, the justices rejected the defendant's claim that they were entitled to absolute immunity, that they couldn't be sued because they were government officials. But in light of the vagueness and breadth of the lawsuit's allegations, the court also decided that liability would require the plaintiff to prove the defendants had violated a clearly established rule, that they had no good faith reason to believe that they were behaving legally. Seems unfair to punish someone for breaking a rule he could not have known about, Mr. McNamara writes, and I agree. But the earlier standard also required that the official's action be objectively reasonable. And judges often apply an absurd level of precision in defining the rule before asking if it is clearly established. Take the case of Ms. West and her dog Blue. Nobody seriously believes that consent to enter a home is permission to lob grenades into it. But no court has ever decided the question because, as far as he can tell, this is the first time anybody's made the argument. Since no court has considered it, qualified immunity means Ms. West loses. As long as an official's conduct is uniquely outrageous, it's impossible to hold him liable for it. Courts have awarded qualified immunity to police who sicked a dog on a surrendering suspect on the grounds that the suspect was seated. It was clearly established only that you couldn't unleash the hounds on a suspect who was lying down. That's a distinction that most people go, that's absurd. Officials from the Texas Medical Board won qualified immunity after they showed up unannounced at a doctor's office and started rifling through patient files without a warrant. The doctrine even shielded police in Fresno who allegedly stole thousands of dollars in cash and rare coins while executing search warrant. I did a video on that as well. A rule meant to protect government officials from unreasonable lawsuits has turned into a rule that protects unconstitutional conduct. That is why the Institute for Justice, where Mr. McNamara works, is representing Ms. West and petitioning the U.S. Supreme Court to hear her case. This is only the first of many such cases the Institute plans to litigate as part of a new project on immunity and accountability. Ms. West's case is outrageous, but not atypical. Courts shouldn't allow government officials to punch holes in the Constitution or in her walls. And I applaud Mr. McNamara for writing the opinion piece. I applaud the Wall Street Journal for publishing it, because this is one of those rare occasions. It's like when I talk about civil asset forfeiture. I describe it. I tell people what it is. I go, it's happening every day. Here's examples of it. People are outraged. I've gotten and remember, on the internet, people argue with everything. Very few people argue with me about civil asset forfeiture. They only argue and say, Steve, it's not as prevalent as you say it is. Or they'll say things like, well, you're stupid to carry cash. But no one says, but if you carry cash, you deserve to have the police steal it from you. No one says that, okay? And so everyone understands. Yeah, guy's running from the police. He's got weapons. He hides inside a house. People might understand that the police are going to damage the house in the process of trying to eject an armed gunman who's shooting at them. Most people go, that kind of makes sense. And if there's a gray area around that, we understand that. But here, where the woman goes, I don't think he's in there, but go look. They turn that into, oh, that's permission to level the house. No, it's crazy. And I think most people get that. So this is an example where I think, because when I talked about the case where they chased the gunman into the house who stole the belt, Most people said, I understand the police doing what they have to do, but if they level the house in the process, the homeowner should be compensated. And the idea that, oh, no, we can just do that and they don't get compensated. Most people go, that's wrong. But the other case was where the police officers were looking for something and they came across money. And the allegation is that they took the money. They stole the money. And when they got sued, they didn't defend themselves by saying, we didn't steal the money. They defended themselves by saying, you can't sue us even if we did because of qualified immunity. And again, most people go, wait, what? If you accuse me of stealing something and I didn't steal it, I'm going to tell you I didn't steal it. I'm going to go to court until I didn't steal it. I wouldn't let my attorneys make the argument, even if you did steal it, you can't sue him. But that's what they did. It's an absurd result. I think it's an absurd law. So qualified immunity, at least in these settings, is crazy. It's crazy. So thank you for sending the article. I thank the Wall Street Journal for publishing it. I thank Robert McNamara for writing it. And I do hope that the Institute for Justice can get this case in front of our Supreme Court. Sadly, I don't know how they rule on this. But maybe the pendulum will start swinging. Who knows? Maybe the laws will change. We can dream, can't we? Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. All I heard was blah, 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 blah.